Workplace accommodation, we often hear about it. What happens if someone is having a problem, a health problem that requires special accommodation? What must an employer do? Well, it takes us to this week's case. Involves a real woman, Christina Brady. She worked for a company in Pennsylvania, United Refrigeration. She developed a heightened sensitivity to various fragrances. She said they gave her extreme migraines, prevented her from concentrating, and in short, prevented her from doing her job. So she asked her employer to do some accommodation. And the employer did a variety of things. First of all, they sent out a memo. She was working on the first floor of the building, and they sent out a memo that said everybody on the first floor are prohibited from using colognes or any kind of perfume, any kind of fragrance, and additionally shouldn't use any soaps or other products that would produce a fragrance. Okay, so that went out. They were enforcing that. Well, unfortunately, Christine continued to have problems. Turned out that the person who was sitting near her at the workplace was someone who had a skin condition that required a special soap be used for the skin condition, and that the fragrance of that soap was what in fact was causing the problem, or was thought to cause the problem. So her workstation was then moved. The folks she was working for made efforts to completely clean the area in which she was going to work, specially shampooed the carpeting, did a number of other things to make sure all fragrances, all odors were removed. She continued to have some problems. It turned out that there was something used in one of the cleaning products that was used at the place of work, and so that was discontinued. This went on for some period of time, and finally her employer wrote her a memo, said, look, we've tried all of this, Christine, and they listed line, verse, and chapter, everything that they had done, and they said, you know, there's really nothing further, Christine, we can do, and therefore, since you're not showing up to work because she was taking time off of work since she had her migraines, unfortunately, you are laid off. Well, Christine, through her attorneys, said, hang on a second. I wanted to bring a claim for Family Medical Leave Act. That's an act that was passed by Congress in 1993 that provides an employer must provide unpaid leave for somebody who has a medical condition. Well, she said, I wanted to bring that claim. I never had a chance to bring that claim, and as a result, I was denied the protection of the Medical Leave Act, and I am bringing claim here in federal court. So the claim went forward. On behalf of the employer, the argument was made, wait, you don't have any claim here. While you certainly made a claim while you were working for us, we never rejected the claim. We never turned it down. We were trying to accommodate you, doing everything we could so that you wouldn't have to utilize the Federal Medical Leave Act. And therefore, we never turned it down. She, through her attorneys, argued, yes, you did, because constructively you denied it since you never actually allowed me to have medical leave. Okay, so the case goes to the judge. The case goes to the judge. He hears both sides of the story. And at the end of the day, the judge decides that, Christine, you and your lawyers are right. You and your lawyers are right. Because in this instance, your employer did not provide you with the Medical Leave Act that you sought. Now, granted, they say they never turned it down, but because they sat on it a long period of time and because you were fired before they ever acted on it, they constructively denied your claim, and therefore your claim was turned down. Therefore, you can move forward on this case. Okay, so what do we learn from this case? Well, what we learn from this case is an important thing, and that is that when you have some rights that you have not fully asserted during your employment and you're terminated from your employment, you may still have the ability to bring those claims if you had at least placed your employer on notice of those claims before you left or before you were fired. Okay, well, we bring you this case as we bring cases every week so you understand how the law works. I'm David Allen.